before the dawn, the town still half asleep. Young Jeff Middleton on the truck, trash piled deep. Count the coins in his pocket, dreaming bigger than the day, wishing he could clean up the town in his own judicial way. He wiped the grime off his brow, took a long hard look, thought about the simple life, the one outside the book. Then a grin cracked through the heat, the truth came clear enough. All I need's Italian sausage and a corn dog. That'll fix me right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more, no less. A young man in a buggy, sitting down in court, tried out the big world, but his joyride fell short. Judge leans forward and says, wait just a minute, son. I know all about Rum Spring, I've seen where the road runs. You've been pushing your limits, testing every curve and bend, but if you keep that pedal down, the road will get you in the end. Middleton smiles wide, there's a good advice land. All you need's Italian sausage and a corn dog. That'll fix you right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down and the road's a mess, that'll fix you right up. No more, no less. Here comes a man, paper stacked up high, spouting soft city lingo, thinking he's sly. I need proof of jurisdiction, he argues and screams. Middleton leans back, YouTube gets it seen. With a wink and a grin, he shuts the whole thing down. I won't entertain that Jabberwocky clown. Then he lands the truth that makes the courtroom erupt. All he needs is Italian sausage and a corn dog. That'll fix him right up. Remember Judge Middleton said all you need's an Italian sausage and a corn dog. When life's got you down.
All right. Happy New Year, everybody. Hello. I'm in Auckland, New Zealand. It's already the new year. It's been the new year for 4 hours now. Why am I up? Because it was rainy. It was rainy, so I napped in the middle of the day. I did. I've been in a lot of different time zones. I napped during the day. Went out on Auckland Harbor, saw the fireworks. I tried to stream it, but it didn't work. Don't tell the Kiwis. Don't tell them I'm here. We'll discuss it all after I've left. Thanks for coming out. Meanwhile, while I'm out in Auckland Harbor partying, Zach over at Law Nerds Unite hooks me up with fantastic material for the new year. And I can't wait to get into it. I think we've got a throuple. At least that's what he's telling me. He tends to be right. Let's give it a look.
And Your Honor, that was it for the out of order.
All right.
Thank you.
Then that'll take us back to Miracle Brady. I think 2 cases.
Morning.
Hello, ma'am. How are you?
Doing fine. How are you?
I'm sorry. It's habit. I know you're in jail and it's no good. So you're here on an old traffic case, and then we also have a pending. Let me make sure we did get the file. You also have a charge of domestic battery, first offense. Do you understand that?
Yes, I do.
Okay. Mr. Edgerton, the plan is to enter a not guilty on the domestic, I'm guessing, today?
It is, Your Honor. And Miss Brady was not sure what she wanted to do with that traffic charge. I was indicating that it might be in her best interest to just wrap it up, but she wasn't totally sure whether that vehicle was registered back in April of 25.
Okay. So, Ms. Brady, I can absolutely deal with these things completely separately in my mind. If you want to take care of the registration charges, I can do that, and that doesn't have anything to do with your domestic charge. I will certainly give you time to show me proof of registration if you had it back then, or if you have it now. I'll give you some time to do that.
Okay.
Okay, but you're going to have to bail out on this domestic battery charge probably. Do you understand that?
And do you know how much that is, or do I know?
I haven't made a decision on it, but it's going to probably be somewhere in the neighborhood of $2,000 to $5,000, I would guess.
Okay.
All right. Is there going to be any chance that you're going to be out of jail? That you're going to be able to bail out?
I can. I have when I was getting detained, I do have cash at home, but it is don't have my family's in like Sacramento and Oakland, so I'm not sure if they could go get it out of my house, but I can see if they can just kind of help me out, and then I can get it when I get out at home. But I definitely do have money saved up, so
Okay.
yes.
How long have you been in jail?
Since Saturday. So today's the 4th day.
All right. Well, I'm not trying to force you into anything one way or the other, but I'll tell you, if you want to resolve the registration charge,
Good for her. I applaud her for having bail money set aside. That's good.
I'll close it out with time served for you here today. And then you can just deal with the domestic battery charge.
Okay.
You want to do that?
Yeah, so I would just have to pay that one, is what you're saying?
No, I'm going to take a couple of days of the credit you've already been in jail and close the case out.
Okay.
All right. Okay. Do you admit to me that you failed to show up for court on March 8th on this registration charge?
Yes.
Okay.
Yeah.
What's your plea then to driving without registration on April 8th of 2025? No contest?
Yeah. Yeah.
So if you plead no contest, it's sort of like a guilty charge. You're taking responsibility for it. You want to do that?
Yeah.
Okay.
Not sure.
I'm going to take a no contest. What I'm going to do is give you 1 day credit time served against the warrant, 1 day credit time served against the registration. That matter's closed. Okay.
Okay.
All right. Let's talk about the domestic battery charge. Not guilty has been entered. Legal defender been appointed already. Let me double check on that.
She refused.
Okay. So Ms. Brady, you said when you went into jail that you didn't want to talk about a lawyer. You were going to hire your own lawyer, something like that. What do you want to do about that?
I can, if you guys have one for me. I just really didn't understand. It was my first time and all that. So it was a lot of words being said. I really didn't understand.
I got you. However,
Words are hard, Judge. It does remind me of Beavis and Butthead when it used to sound out word.
I want you, before I just appoint a lawyer, it seems like you've got to, you may make some pretty decent money. I want to see how much money you make. I'm going to have you fill out a financial application for a legal defender before I appoint one. Okay.
Okay.
Words are very unnecessary.
At this point, legal defender has been denied, but you may fill out an application, fill out the financial paperwork. Okay. All right. Ms. Avoidis Tanner, what's the recommendation for bail?
Thank you, Your Honor. Ms. Brady is 25. She scores a 7 on the MPRA, which is interesting considering that I don't have any criminal history for her. So she's getting points for other factors that should be considered. As far as the pretrial assessment report, we learn that she reports living in the Reno-Sparks area for 2 years at the listed address for that entire time. She reports part-time employment with the same employer for 1 year and 2 months, and that employer is Fantasy Girls. She was unwilling or unable to provide a reference, and none of her personal information was actually
Fantasy Girls.
verified. She reported she resides with the alleged victim, but could reside elsewhere if released from custody. Of course, although she has no criminal history, we do know that she doesn't show up to handle her court matters as
Ma'am, are you a whore?
evidenced by that earlier 2025 FTA on the registration case.
I mean, I'm required by international law to play that if you disclose your employer as fantasy girls. I'm sorry.
As far as what we learned from the probable cause statement, in that statement is alleged that she scratched her significant other. Your Honor, of concern to the city is that in the probable cause statement, there's a lot of information that Ms. Brady provided to law enforcement, which after concluding their investigation, law enforcement determined that the information was not correct. So I don't know how honest Ms. Brady was with law enforcement and how honest she was with pretrial services and how honest she's going to be with the court. So with that, my argument is that risk to the victim is established, that she doesn't.
Was it a fun scratch or a mean scratch? Inquiring minds want to know.
Show up to handle court matters as evidenced by her history. I am going to ask that you impose bail in this case. I'm going to ask for $2,000 bondable. And this is also taking into account her score of 7. So I'm going to ask for $2,000 bondable, that she be required to abide by a no contact order with the alleged victim in the case. For the court's information, the alleged victim is in custody. He's in custody on failures to appear, not in custody because of this case. He's got other cases they failed to appear for. And I'm going to ask that if she's able to bail out, that she be required to check in with.
I, for one, like a good back scratch. You know, I don't think that's actionable. I think that's encouraged.
Court. Thank you.
Thank you. Mr. Edgerton, please.
Thank you, Your Honor. Again, I want to start with the fact that Ms. Brady has no prior criminal history that we're aware of. Again, her MPRA is a 7, and I frequently start there. I will echo the city in acknowledging that that's a bit of an unusual score. And so again, let's look at those points, right? 3 points are coming from the fact of the failure to resolve that that no registration charge. That's 2 of her points for having a pending case at booking. So like another individual we saw today, is there a pending case at booking? Yes. Is it of a nature that ought to raise recidivist concerns? I would argue not. Age of first arrest, again, the fact that she's 25 and she's been arrested is giving her a point. The other 4 points in her 7 are coming from unverified information. We know she works. We know she has an address. We know she has a functioning phone. We just weren't able to verify that during this slow holiday weekend. So I could argue that she's an MPRA 0. In any event, I would argue that she's a low if we properly consider her score, which places her in the bottom 15% of defendants in terms of likeliness to reoffend or not come to court. The city indicated that she fails to take care of her court matters. I would rephrase that as she has once failed to deal with her court matters. We're only aware of a single traffic.
I like this hypothetical. If we forget about the score that she actually has, then then she's very likely to not reoffend. Okay. And if the queen had balls, she'd be the king.
Citation that she failed to come to court on. She seems a bit overwhelmed by the process. She just didn't kind of know how to handle that. I think the city is also correct to point out some concerns about exactly what happened this evening. I think there's a couple different readings here. One reading is that Miss Brady is sophisticated and is intentionally misleading law enforcement. Another reading is that she was embarrassed or uncomfortable by the situation. Again, there was a male alleged victim with whom she was having a sexual encounter, as well as a female partner. She might have been, in her feelings about that dynamic, not wanting to expose people.
A throuple and in your feelings. I doubt she was in her feelings. Sincerely. I don't have my throuple clip because I'm on the road. It hurts me. It hurts me in the worst way, but I'll just say it. I'm in the wrong world.
Based on that kind of those intimate details. Her partner also was arrested on some warrants. We actually have him in court today on, again, traffic matters that he was not taken care of. So it could have just been sheer embarrassment that caused her to be a bit obtuse, I don't see anything else. There's even a reading of this that, you know, she's, as the city indicated, she's an exotic dancer. There could be trafficking concerns where she potentially is.
Yeah, she's not. Because it was a throuple, it's a bit obtuse. What the hell are you talking about? She's not worried about it. She's a pro. She's a pro. This is a job. This is like saying you're a DoorDash person's afraid to deliver somebody a hamburger. No.
A victim. So I don't know why she was being evasive with law enforcement in that particular moment, but I don't think it speaks to a likeliness that she's not going to come to court. I would argue that she can be released on her own recognizance. It sounds like both she and the alleged victim have elsewhere that they can go, as long as they're enjoined from having contact with one another. That satisfies safety concerns. Thank you.
And I'll tell you, ma'am, that's my main concern, is that there's going to be no contact with you and Mr.
Dixon Petrus.
Yes, thank you. I saw Tyree, but I couldn't find the last name there. Anything you want me to know, ma'am? Just about your living situation, really. I've got you. I do have an address for you saying that you've been there for a couple of years. What do you want me to know?
I do live there. I was in the process of moving, so I don't have to be next to him at all. Like, that's not something I'm like not trying to get back to him super quick. If we need to be apart, then that's perfectly fine. But yeah, that's mainly, I was definitely embarrassed. So it wasn't that that I was just trying to like live and do all that. I was just definitely embarrassed, and that's pretty much all. Never been in trouble before, so it's like.
Yeah, and I can see that.
Oh, she's a bashful fantasy girl. Okay.
You know, we do have the one traffic matter that you didn't take care of, which is a ding again.
Oh, good Lord. Judge Champagne here is going to simp, isn't he? He's buying this. All right, let's do it.
It's not the worst situation in the world. Let me let you know this. The first judge looked at this matter. He read through all the reports. He set your bail at $3,000. Excuse me. The prosecutor's asking me to set it at $2,000. I'm going to go below that. I'm not agreeing with your lawyer totally, but I'm going to set your bail at $1,500. It will be bondable. You will be on pretrial supervision. No alcohol, no drugs. You'll be on basic supervision, which means that the marshals could test you whenever they want if they have any reason to think that you've been drinking or using. You don't have to go to AverHealth every day and test. You're not going to be on a schedule, but they have the right to test you. Do you understand that?
I do.
Okay. There will also be no contact with Tyree Dixon. Excuse me. Tyree Dixon -Petrus for 120 days. You're going to sign a no contact order on that. You will obey all laws, and you will check in within 24 hours of your release here at the courthouse for pretrial supervision. All right. Okay. I think that at $1,500, that's a reasonable amount for you. I am again inviting you to fill out the paperwork for a legal defender. If you want to hire your own lawyer, knock yourself out. Okay.
Okay.
Okay. Good luck.
Ma'am, come over.
All right. Let me just make sure I've got all my notes here. 1,500. Obey all laws. No alcohol or drugs. Basic supervision. And no contact with Tyree. Tyree Dixon Petrus. All right. Next up then will be Christopher Burrows.
Fantastic. And like I said in the title, we're off with a bang. Now let's go to something completely different.
What's your name, sir?
Thumb.
Say that again, please.
Thumb.
Douglas Thumb?
Yeah.
Ms. Kamir, did you get a chance to speak with him?
Who?
I did, Your Honor.
I was asking the attorney if she spoke with you, and she just said yes. So, Mr. Thumb, looks like you're here on a pre-FTC in Lacey on an older theft from 2024. Then there's a new allegation of theft alleged to have occurred on December 25th. And Ms. Kamari, did you get a chance to speak with him prior to court, discuss with him his legal rights?
I did, Your Honor, and he's currently engaged in the diversion program. And so I defer to the forensic navigator regarding that process.
Totally off my match.
Proceeding forward with this case in the diversion
So,
program.
Mr. Thumb, let me hear from some people here, and then I'll come back to you in a second. So, Ms. Crawford, or Churchward, sorry. Did you meet with him, or where are we at with him?
Yeah, so myself and our FPath provider met with Mr. Thumb this morning, and talking with him, we discussed like how we can move forward and get him the help that he needs. He has
I'm trying so hard to be good. I'm trying to be so hard to be good. It hurts.
told me that he would like to be inpatient at Western State Hospital, but unfortunately that isn't going to be quite an option. However, we have, not myself, but our FPath provider has submitted a referral for Northwest Resources to have an assessment done for co-occurring inpatient treatment. Which I don't have an ROI for Northwest Resources, unfortunately. So I would have to go back out to the jail to see where to get that ROI signed and to touch base with Northwest Resources. But to my knowledge, that should be happening. That assessment should be happening here in the near future. He has been participating in diversion for about a month, maybe 2 months now. And he has been making a lot of his appointments. He has been staying in communication with myself and our FPath and FHARPS provider. So I'm hoping
he's been awesome until he did this.
that we can figure out the inpatient process so that he can get back on his medication and stabilized.
He's got all these warrants from all over the place. I see your hand there, Mr. Thumb. Let me talk with some of these other folks first here, and then I'll hear from what you have to say. So I guess the concern is in what case?
Oh, good Lord.
Was he participating in the diversion? Was that a Lacey case for criminal trespass or what exactly? Or
one moment. I believe it was out of the city of Lacey, and it was a criminal trespass.
Right.
I believe the one ending in 857.
Right. So what's alleged to have occurred on the 25th? Christmas of all days.
I stole Santa Claus.
Mr. Thumb. He allegedly took a Santa decoration from the Comfort Inn into his hotel room.
I stole Santa Claus. It's light, but he says it. Zach is on fire.
Staying at the hotel room there?
My understanding, Your Honor, yes.
Is that part of the diversion program, Ms. Churchward?
Yes, it was a part of the program to have him stay at the Comfort Inn until he was more stably housed. After talking with our FPath provider, he was going to speak with FHARPS and talk about getting him involved in a shelter so that he can be around more people and have a little bit more accountability.
All right. Well, first of all, let's back up. We're going to back up here a little bit. First of all, on the theft, Ms. Kamari, are you stipulating the probable cause?
Yes, Your Honor, but we are requesting a dismissal so that he can participate in the diversion.
What's let me see what the city says.
I thought he was arraigned on the 26th.
It doesn't look to me like he's made court. It looks like he's been been a couple of refusals.
Maybe he started and then got continued. I guess I would defer to the court, Your Honor. I'm not as familiar with the diversion process.
Well, the diversion, it can be dismissed without, which if you look at the, that criminal trespass, which is why I asked.
Right.
It looks like it was dismissed without prejudice, and then they go on the diversion program, and then it sounds like he's been there for somewhat successful. The circumstances surrounding the allegations here don't seem,
Well, and
quite frankly, wasn't what I expected.
I think there's a little more to it than what was presented in terms of what happened on December 25th.
Okay, well, go ahead. Why don't you let me know then?
It says that they got a report from the Comfort Inn that the customer was harassing staff. And they responded. The clerk said the defendant was demanding a kiss and said he was going to kidnap her and bring her back to his room. That made her uncomfortable. She didn't know how to respond. She said at one point he made the gesture that he was going to flash his genitals at her. And then she noticed the 4-foot Christmas decoration or a Santa was missing.
This just gets worse. It gets so much worse. First of all, he steals a Santa, which is just dumb. No, let's back up. First of all, he's on diversion for something else. While on diversion, trying to not get a conviction on that, he steals a Santa. But he doesn't just steal a Santa like he got drunk and went and stole a Santa. That's kind of funny in and of itself. But no. He's stealing this Santa in connection with creeping on this chick. What are you doing, dude?
Another front desk clerk said when he called the defendant and asked him to return the item, defendant told him, and I quote, "fuck off," and hung up the phone. When advised that he would have to leave the property and be trespassed, when the clerk called him back again, he said, and I quote, "kiss my ass." And so that's when I believe the clerk called 911. It also sounds like he kicked out a screen and it fell to the ground and hit a customer's car.
So on December 26th, he was in front of the court. He did appear. Probable cause was established. He was held without bail, and who was here for Mr. Swenson was here. Apparently, he was returned to custody without him being arraigned. And then it was on the 29th, which was yesterday. And it was a refusal. And so today he's here for arraignment. And so Mr. Thumb, again, you're now charged with 1 count of theft. That's a gross misdemeanor, carries with it a maximum penalty of 364 days in jail and a $5,000 fine. Plea of not guilty will be entered. This matter will get set for future hearing. There's also a non-compliance on an older, or maybe I'm wrong about, no, you're right. An older Lacey case, 8773. So we're going to set conditions of release on all of these. I'm going to hear from the city. Then I'll hear from Ms. Kamari and Ms. Churchward. I may or may not have some questions for you also, but thank you for being here.
And the city, Your Honor, would either, I guess, ask for $1,000 bail be set on each case, or alternatively, the city, we could potentially continue it tomorrow for DSHS to reformulate his diversion plan, since it sounds like he still needs to set up new housing. And then tomorrow, the city might have a better position on where they stood on the diversion.
Wow.
Ms. Kamari?
Wow.
Your Honor, we are requesting release on personal recognizance. He can continue coordination regarding his diversion program with Ms. Churchward.
So Ms. Churchward, you have any idea what, this might seem like a dumb question in light of what I've already heard, but what happened out there? What, I guess maybe it's better asked, what went wrong? Or do you have an idea, or do you have a sense, or not?
So
What went wrong? I think it went just the way he wanted it to. He went and creeped on somebody and then took a Santa. What that was the plan, Judge.
with my position, I try not to hear about the case at all because I don't want to sway the court one way or another. To my,
You don't have to. If I'm putting you in a tough spot that you don't want to respond to, you don't have to do that. I'm not going to put you in that position.
Yeah, no, I hear you there. Yeah, if I feel like maybe Mr. Thumb would have a better sense of saying why, but yeah, unfortunately, I don't believe I can say.
Fair enough. Thank you. And I apologize for putting you in an uncomfortable situation there.
You're fine.
So go ahead there, Mr. Thumb. I don't want you to talk about what happened at you heard some allegations coming from the city. Don't want you to respond to those. Don't want you to respond to the Santa situation, for lack of a better term. But you wanted to say something.
I can go back.
Go ahead.
I've been hearing voices really bad. I want to go back to South Sound.
What's South Sound?
Huh? It's the mental hospital in town. I've been hearing voices and seeing things. That's why I did what I did.
I am no expert, but I'm skeptical about that. It just seems too convenient and too rational the way it's presented. I don't know, but he certainly should be checked on. But that just sounds like, oh, I'm just going to use this as an excuse.
I'm on meds. They haven't given me my meds since Christmas Day.
So here's what's going to happen today here, Mr. The Thumb. Well, let me come back to you, ma'am, Ms. Churchward. Do you have an indication of how long, getting him set up at inpatient Northwest Resources, how long do you think that can take? How long can it take for him to go on a furlough for there?
So with that, I'm unsure. I believe Northwest Resources, their co-occurring or dual diagnoses treatment, I believe it's 28 days long, if I remember correctly. I would need to go back to Nisqually Jail and get that ROI signed so that I can coordinate with Northwest Resources. But from what FPATH had told me, it should be with that assessment should be taking place here within the next couple days. And with South Sound Behavioral Hospital, I can try to see if they have an available date.
All right. And then Ms. Kamari, here's what I'm inclined to do. Based on the nature of the allegations combined with the multiple warrants out of many jurisdictions, I'm going to set bail in the amount of $500 in each case for a total bail amount of $1,000 cash or bond. I can set this on as soon as today's Tuesday. We're not having court on Thursday, of course, either tomorrow at 1:30 or Friday at 1:30, and then we can revisit and see where you're at in terms of getting him a bed someplace. And then a furlough can be entered then, and then, or maybe some sort of agreeable diversion plan will be in place where that can be facilitated. But, and so then Ms. Kamiri, I'd come to you to see what your, and then Ms. Churchward, do you have I mean, can this happen as soon as tomorrow, or would be Friday a better date?
Friday would be a better date for me, just to make sure I have everything in place.
Okay. And we'll do that on at 1:30. And then Ms. Kamari, whoever's going to be here from your office on Friday, if you could let them know what this is all about.
Yes, Your Honor.
And I'll set it right on the 1:30 calendar. No, rain is not be a pre-trial from the new charge.
For a rainy.
Raining today, yep. And that's it for today there. You can be taken back. We'll see you Friday. And then the other case is pre-FTC.
I can't help everybody all the time, and it hurts me sometimes. Leah Smith. Hi, Ms. Smith.
Good morning, Your Honor.
Okay, looks like we just have the one case, 25 CR 19272, which is a charge of reckless driving. Do you understand that?
Yeah, it was kind of a big misunderstanding.
Nope. I don't want to hear about the case yet. I just want to make sure you understand what's happening here today.
Yes, I do.
Okay. Counsel, what's the plan this morning for Ms. Smith?
Ms. Smith's going to be pleading not guilty, Your Honor.
Okay. All right. Is that what you want to do, is to plead not guilty and set the case for trial, ma'am?
Yes, that's correct.
Okay. I will enter a not guilty plea for you. Let me just pull this up here very quickly. You just got arrested last night.
Yes.
Okay. All right. Bail hasn't been set on this matter, it looks like. Ms. Aboitis Tanner, what's the city's position as far as a bail on the reckless driving charge?
Thank you.
And then, well, let me ask, is there something else keeping you in jail?
No, Your Honor.
Okay, just the reckless.
Thank you, Your Honor. We've seen Ms. Smith one time before in our court on a trespass, and that was in January of 2025. It looks like her case was dismissed because she was found not competent. And in this case, what we learned in the pretrial services assessment report is that she's active with competency court for a case from 2024. She reports she's been living in the Reno Sparks area for 1.5 years and her current address for 6 months. She is not employed and supported by government assistance. Now, the allegations in the probable cause statement are concerning. It is alleged that she pulled in front of a patrol vehicle. The defendant stopped her car in the officer's lane of travel in the middle of the roadway, got out of her car and told the officers she wanted to go out with him after work. Your Honor, I don't have access to her full criminal history. I can't tell you today if she has FTAs on her record. What I can tell you based on
That's aggressive, but I like her pluck.
limited information that I have is she is participating in a specialty court and she is allegedly violating the law. I have mental health concerns based on the allegations in this case, which place the officer at risk, in addition to the fact that she was found incompetent on a case earlier this year. So with that, I am going to ask that you impose bail based on the danger that she poses to the community and law enforcement. I'm going to ask for $1,000 bondable, and that if she's able to bail out, that she check in with the court. Thank you.
Thank you. Mr. Edgerton, please.
Thank you, Your Honor. Without diminishing the safety concerns that the city's articulating, I just don't know that monetary bail is the mechanism that's best suited to deal with that, right? This is someone who is struggling with mental health issues, is in competency court, has access to not only DAS supervision, but also the special resources available through Judge Walker's competency court. Her next hearing is the 16th of January, and that was something that I raised because it was part of my conversation with her about what would happen if she remained in custody. That's, going to be almost 3 weeks of being in custody on a reckless. And again, the nature here is that she basically had this kind of like that irresistible impulse language that we get from, the insanity defense in certain jurisdictions, where she had this urge to talk to an officer. She wanted to talk to someone about potentially doing a ride along. That was the nature of that conversation. And saw an officer, wanted to kind of have that conversation right then and there, and couldn't kind of subordinate that impulse.
She wanted a ride along, you say?
And so pulled out abruptly. Fortunately, everyone was okay. It was just a strange impulse that she just needs to kind of govern better. But I don't think that monetary bail is the right mechanism. It's just going to have her locked up. So I'd ask the court to release her on her recognizance, to comply with DAS supervision, and also to check in with the court as needed.
Okay. All right, Ms. Smith, I've got you listed here with an address over on Victorian Avenue where you've been for about 6 months. Is that right?
Yes, that's correct, Your Honor.
If you get out of jail today, are you going back to that apartment?
Yes, I am.
When's your next appointment or your next hearing with Judge Walker?
On the 16th, January 16th, but I actually have.
Oh, that's okay.
I actually have.
I thought that was the trial date. I guess that's way too fast. I'm sorry. I wasn't thinking right.
And I also have a drug test to take today at pretrial services.
Okay. All right, Ms. Smith, I'm not going to keep you in jail. I'm gonna let, I think Judge Walker is the best judge equipped at this point to deal with your matters. What I'm going to do is I'm going to release you on your own recognizance, but there's multiple things that you're going to have to do for me. Okay.
Mm-hmm.
Hold on just 1 sec here. Let me make my notes. Not guilty. OR'd. Okay. Number 1. You must obey all laws. Do not break any more laws. Don't get arrested for anything else, okay?
Yes, Your Honor.
Do you have a valid driver's license right now?
I do.
Okay. All right. So you can drive if you're legal to do that. But if you don't have a license, I don't want you driving, okay?
I do have one.
All right. Obey all laws. No alcohol or drugs without a valid prescription. You're going to be on basic supervision. That means that the marshals can test you if they have any reason to think that you are using or drinking, okay?
Yeah, I'm 11 months sober.
Excellent. Congratulations.
Thank you.
That's hard work, so keep it up.
Mm-hmm.
All right. Number 3 is I want you to comply with the competency court, okay? You got to make sure that you make your hearing with Judge Walker and do what he wants you to do.
I always.
Good for you. Good for you. You're sober, but you're still kind of doing things that sort of drunk people would do.
All right.
I'm actually getting ready to graduate.
Oh, congratulations. And so you've done a lot of hard work.
Yes.
Good. So let Judge Walker know what's going on with this case. He and I know each other, and he knows that I'm working with people that we kind of cross over. So let him know what's going on. And what I need you to do is when you get out by tomorrow at noon, I need you to come down here to the courthouse and check in with us.
Okay.
Just so we know who you are. We can get all your information and be ready to go. Okay.
Okay. So come down here and check in.
Yep. Do you know where Judge Walker's courthouse is? Do you go in person down there?
I go in person. Yes. At the judicial.
We're right across the street from Judge Walker's courthouse.
Oh, okay.
The new courthouse across the street. Okay.
Oh, okay. Sounds good. I'll be there.
All right. Good luck, ma'am.
Thank you.
ROR noon tomorrow.
Court calls case of People versus Joseph Hafner Cantor.
Alex Warren, Green with Hafner Cantor. Here, Your Honor. You state your name.
Joseph Hafner Cantor. All right, what are you doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me. Where? Bond continued. Thank you.
Right. I think last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation from that? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I've got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr. Allen.
with positive alcohol blows on the silver line.
We've got a positive on December 8th. And then missed test really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him. And he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner Cantor is changing his position on that.
Really?
He did appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond
On this case?
He was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was, after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner Cantor is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond, because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking.
Yeah, but this response from the people.
The people are glad that he has now a scram order on the OWI case that's pending before Judge Frushauer. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it does.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that the SoberLink is not working. So I would ask that the court, at the minimum, order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
I did not give him one.
So there was a warrant issued on this one. Okay.
Okay.
Is it still out?
For Mr. Hafner.
Yeah.
Okay.
No, I do not see that a warrant.
Oh, you do not see that
No, I
one.
do not see. No. So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation would be sent, and I was affording him the opportunity to take the ETG test to provide results with my report if in fact he was not drinking.
This better end with jail. I don't know what happens, but there's no other choice. He needs jail. It's not the worst offense of all time. It doesn't mean he's a horrible person, but he cannot. He's doing this while he's out for another DUI. This guy is completely out of control. Jail until treatment. No freedom.
And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of time frame.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then.
She was aware, she remanded him, and
But was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drink coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And yeah, we don't do that. You say whatever you want.
Your Honor, I think what Mr. Hafner kind of wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying the problem.
Right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner-Cantor, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually tested at the court, but because he had the .04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make sure.
So he wasn't breathalyzed at court.
Now that Mr. Cook's aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair. Yeah.
Anything else?
Your Honor, I know Mr. Hefner Cantor's been in constant contact with his community corrections agent. And I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter. And
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing from the view.
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor,
Yeah.
and
The 13th is,
and with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
district court where?
for the OWI case.
Well, he wouldn't exam until much later.
Which judge was the exam?
Eh.
Thank you.
Thank you, Your Honor.
They don't even have roads. That's what I hear. Do they? They do?
Yeah.
In Ohio? Oh, you're from Ohio. You are, aren't you? I mean, the other side kind of, because you're from like Cleveland area, which nobody claims.
Cleveland period.
Yeah, but do we really listen to that? No. Okay, good. Nice chat. Corco's case, people versus Quadir Man.
He said that we have the people around.
Assistant Public Defender Ben Benowitz on behalf of Mr. Mann, who is standing to my right. Sir, would you say your name for the record, please?
Quadir Man.
Thank you.
Your Honor, we would like to set this matter for exam.
All right. Discovery is complete.
Discovery is complete.
People had their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before 15th District Court Judge. Yes.
No, it came to my attention in looking at the defendant's jail calls before he was released and after he was arraigned. He made 50 calls to the victim on his PIN to her listed number after being arraigned.
I beg your pardon. I was out in Auckland Harbor watching the fireworks, cocktailing, everything at midnight, New Zealand time. It is now 5 o'clock in the morning in New Zealand, 4:55. And here I am.
That doesn't count the day that he was arraigned after he was arraigned. That only encompasses days exclusively after he was arraigned. He calls her 50 times. So I have concerns given that also at arraignment, the magistrate indicated his concerns that he will not follow court orders and that he would go back to contact the victim as soon as he released. And it seems that he didn't even do that prior to being released. He did it while he was still in custody. So I have concerns given now that he is out for safety. I also have concerns given the facts of this case in which his grandmother's, the person who reported the crime after she awoke to blood curling screams from the victim and felt she had called 911 after hearing the victim being slapped. So I have concerns for safety given that he was contacting her excessively from jail.
When was he released?
I'm sorry, could you?
When was he released from jail?
I believe it was the 26th and he was arraigned on the 24th after being arrested on the 23rd.
It sure is. It's 2026 here.
Could I attempt to respond, Your Honor?
Go ahead.
My response is primarily based on the facts of the case. This complaining witness stated she was not assaulted. The grandma did not witness any sort of assault. As the prosecutor told you, she said she heard something. So there's no witness that actually witnessed an assault.
Stop it, Nigel.
So then,
just stop it.
Your Honor, the police say he's laying on a mattress with a blanket on him, which we would commonly call sleeping. The complaining witness tells the police he has a head injury from falling down. Okay. So he's sleeping and has a head injury. The facts of the felony charge in Washtenaw County in 2025 is that he had to be told 3 times to turn around and 4 times to back up. And that's a felony. And now we want to revoke his bond, which is basically a due process violation because you take away his trial right. His trial will be in about 8 months.
Why am I taking away his trial right?
Because if he's incarcerated, then it's make a get out of jail plea. I mean, he's talked to.
It's not, counsel.
No, that's a bond violation because you couldn't behave yourself on the way to trial.
And quite frankly, this court resents that you even make that argument that this court would be involved in violation of anybody's due process rights. He's given conditions. If he does not follow those conditions, he pays the consequence.
I agree. I just indicate to the court, I don't think the person that the condition is regarding wants that condition. She didn't want any of this. And then
there's a way in which that's taken care of, not by him continuously calling. He knows he's not supposed to be
I mean, Your Honor, he's 19 and it's Christmas. I just asked the court to give him a chance until we have a date on the 13th. I mean, if this witness says he's contacting her currently, she comes to court on the 13th and tells the court there's a bond violation. I clearly don't have an argument to that, but if the court would let him stay out to the 13th and he's not going to contact.
I don't know what he's doing now. I mean, that's what part of the problem is. Part of the problem is that, and by the way, not only is your client entitled to due process, but the people are entitled to due process. Everyone is entitled to due process, and it is my job to make sure that it happens. If I believe for whatever reason that he may be interfering with the people's due process rights to fairly present their witnesses and have their witnesses present, then I'll take action, which I'm about to do now. Right now, his bond is revoked. Defendant is remanded. Thank you. Yes, and his phone privileges while in jail are revoked. Put that, can you?
Would the court only revoke as to the 2 persons with no contact orders?
I'm revoking his phone privileges.
Okay, thank you.
Court calls the case People versus McKell. Is it?
Good day, sir.
Urquiza?
I believe it's Urquiza, Your Honor.
It was the right
Assistant
call.
Public Defender Davia Liba on behalf of Mr. Urquiza. And Your Honor, Mr. Urquiza would like to waive his preliminary examination. And if you'd like.
Your name, sir?
Miguel Urquiza. And Your Honor would like to address bond as well.
Of course. Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yeah.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Can you give me a second? Yes. Oh.
Oh. How many more of those?
It's a good decision, but it has to be. Yes. Yes, understand.
You understand you will not have that hearing, you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination, having the way defendant is bound over to circuit court on counts 1 and 2 with 3 following.
Thank you, and we acknowledge receipt of the information, waive formal reading and stand mute.
Defendant Ava Wade, former reading standing mute. Court will enter not guilty plea as to all charges. Pretrial will be set for January 13, 2026, 1:30 before Judge Conkey. As to bond.
And with regard to bond, I think the past couple weeks in jail have taught Mr. Akiza a very significant lesson, both about the seriousness of this case and about the importance of following this court's orders regarding bond. He is 20 years old. He is a college at the University of Michigan. He has a supportive family. I believe both his parents are present in the courtroom today. He's told me he is actually doing very well in school. It's a 3.5 GPA, and he's currently scheduled to go back to school on the 7th. He's also told me that he was accepted recently to him.
Why did he lie to me when he came before me?
Mr. Akiza, would you perhaps like to address the court on that?
Like regarding to the Adderall?
Yeah.
Well, yeah, I did. Well, a family member did take it, and I made the, careless decision of taking it. I knew it was going to bring me consequence. I didn't think about that. I didn't think about the consequences before doing it, and which now, I know.
Once you got caught, so I guess what I don't get is, once you got caught, why'd you lie to me? I mean, I look stupid, but I'm really not.
No, I'm not trying to say that, Judge, but after just.
Okay, why'd you lie? Oh, that's a hard question.
The reason why I lied was I was scared. I just didn't know the consequences that would be following it.
Really?
And that was.
So how'd that work out?
It didn't work out really good.
It really didn't.
My fault. So but after spending almost 2 weeks in jail, I learned that freedom is like a privilege that many others take for granted. And after learning that, it's given a chance. I won't take that for granted.
You came up here. It's really funny because you came up here really smug and everything, just doing what you were doing. And I asked you a simple question. You just lied to me, tried to smile at me like whatever it was. And you didn't seem to get it. I don't play that.
I understand.
No, I don't know if you do. Ms. Linda?
At this point, I would object. I think maybe a release to inpatient might be appropriate at some point, based on the mishap.
Kimby mom, we're gonna have to run you through the spanking machine. We can't have this level of decency and niceness here in the chat.
Yes, the THC, the Adderall, and then it was investigated as a part of the underlying charges. So I think there's some issues that need to get figured out before it's just released back in the community.
I have no objection to him being released basically on home confinement with an instruction to immediately get a substance use assessment. But as of now, I don't think there's any reason to believe that he's in need of inpatient treatment.
Okay, let's look at this. How am I going to keep him away from the drugs?
There's always a spanking machine.
I think the past 2 weeks have taught him that he cannot even think about touching substances. I think that's very clear to him now.
So he should have learned a number of lessons. Don't touch that. Don't lie to me.
I think this is probably the biggest learning experience of Mr. Akiza, Your Honor.
Really?
Would you agree with that?
That's a lot of money to pay for the U of M. This becomes your biggest learning experience. Where are you from?
I'm from Chicago, Judge.
Oh, he's trying to roll some Chicago stuff on me. That didn't work, did it?
I'm sorry?
That didn't work, what you were trying to do. Why didn't you just come in and tell the truth?
Well, I was scared. Well, I've never been in this type of situation before in my life. I've never been in trouble. I've never been in this state.
Why didn't you just tell me the truth? Did you think lying was going to get you anywhere?
No.
I mean, that's the other part. Did you think it was really going to get you anywhere?
No.
Why did I have all these missed tests? Because that's the other thing.
Your Honor,
Remember this one instance, but it's positive THC.
Right. I'm sorry. I meant to phrase it differently. You don't have a medical marijuana card.
I don't. But after my release, I don't know why I showed up positive and negative. It's,
You don't know why?
no, I didn't, after my release from, Washtenaw, I didn't take any edibles or I didn't consume any THC. I obviously knew and learned not to.
So how did it get into your system? You're an amoeba.
This is a problem. This guy, I think I've seen a prior appearance. He's got a serious character issue. He cannot be honest. He's smart. He knows better than this. He's not like the biggest criminal of all time. I get that. But he just got his ass chewed for lying to the judge. And here he does it again. Oh, I didn't know. I didn't take any edibles. You probably did. But even if you didn't, this guy knows. This guy's researched it, figured it out, knows exactly what's going on. There's no confusion or anything else. And then he offers as an excuse to the judge, I was scared. In other words, I was afraid of the consequences for my bad actions. So that justifies me lying. My God. Get it straight, my man.
It just absorbed into your system? Why do I get the feeling you're not telling me the truth?
It is. I'm assuming it's bond
Your Honor,
condition.
Mr. Kiza has indicated to me pretty much since this violation of THC came to light that he does not believe he's used THC since.
So this THC, how did it get into his system?
That I don't know, Your Honor, but
Really? You don't know? You weren't there with him?
I was not, Your Honor.
Okay. So he knows.
I believe.
I don't know. No, you know what, young man? Here's what we're going to do. And I hate holding everybody up, particularly the jail. They've been great today getting these people out. I've got some others that are in custody that have to come out. I'm going to send you back. I'm going to do you the favor of recalling your case at some point when you have a chance to speak with your attorney and decide you're going to tell me the truth. I'm not stupid. Don't say anything because otherwise my decision is going to be you're going to sit. Take it back.
Oh, that was wild. All right. We've got a late edition here from Hector Cam Clips via Brecken. Let me find it. I don't know what's going on. All I know is I just got a pile of good material from everybody. Thank you so much. It's a great way to start the new year. I think it's this.
Yeah, your name, sir. I can't hear you just yet. Still can't hear it, sir.
Me neither.
Yep, there we go.
Hello.
Can you hear me? Can you hear me now, sir?
I hear you. Yeah.
Okay, can you tell me
Okay, we're starting strong just with hairdo.
your name?
Douglas Rosman.
All right, Mr. Rosman, we're gonna have you speak to Miss Roberts. She's an attorney
Yeah.
who's gonna help you through your arraignment today, okay?
Yes. I'm innocent. More policy. Yeah.
He kept saying he couldn't understand me, he couldn't hear me, it was breaking up. He wants to
Okay.
have a private attorney.
Okay.
How long will this take? Judge, can I talk to
Mr.
you?
Mr. Rosman, can you hear me okay?
Yeah, I'd like to speak to you. Can I help you?
Okay, well, hold on, sir. All right, let me call this
Certainly.
case and then we'll deal with what's
Oh.
going on, all right?
Yes.
We'll call Township of West Bloomfield versus Douglas Rosman, case number
Oh.
25WB03307. Mr. Rosman, we'll get through this a lot easier if you just let us talk for right now, okay? And then,
I don't want
then you
her
can
to
respond
attorney.
when we ask you.
I'll talk to
Okay,
you.
just,
Go-
yes,
Yeah.
okay, thank you. Go ahead, Ms.
I'm listening.
Roberts.
Rebecca Roberts, appearing on behalf of Mr. Rosman for arraignment purposes only.
I don't want you as my attorney. I have the right to my own attorney. I don't
Mr.
want you.
Mr. Rosman, okay?
I'm here.
Do you have another attorney with you right now?
No, I don't. I wasn't even given
Okay,
the
sir,
right. Nobody
then-
read the. Nobody read
Then,
me my
okay, then
rights.
here's the, Mr. Rosman, okay,
Yeah.
look, if you want to have your own attorney represent you at this arraignment, you can do so, but he needs to be here right now. He or she needs to be here
Well,
right
that's not
now.
gonna happen and you know it.
Okay,
what can I
okay,
do
then
to
you
get
can't
out
get
of here?
arraigned today. Then,
I
sir,
know.
then you can't get arraigned today.
I know.
Okay, then we'll pass the matter, sir.
What? What the hell is
What he's
this?
trying to tell you.
If I don't get an attorney, I'm going back to jail? What's
Mr.
gonna happen when I
Mr.
wait to get a few days? I'm gonna go to
Mr.
jail?
Mr. Rossman,
Yes.
please listen to me. Mr.
All right.
Rossman, listen.
I'm mad.
All right.
Go ahead.
I understand that you're mad, okay? Just relax
Yeah.
a minute,
I
okay?
can't.
We-
I can't.
Well,
I'm so angry, but I will. Go ahead, talk.
all right, sir. Look, we have an attorney present for you to help you through
I
your
don't want
arraignment. Would you like to?
A, we don't care about your feelings. B, there's no going back to jail. You're already in jail. You're just going to stay in jail. That's it. That's all you need to know right now. Now, have you changed your mind or not? Let's find out.
Listen to me, or you just want to do what you want to do?
I would like to listen to you. I don't want to hurt, so go ahead.
Oh, okay. Look,
Help,
all
I
right,
can't hear
Miss
now. I can't
Miss
hear.
Roberts
Everybody's
is-
talking back here. I can't hear you.
Your Honor. It
Yes.
sounds like we might have more to add on to this, so if it's okay with you, we were gonna bring the next one in.
Okay, that's fine.
Apologize before that.
Do I rot in jail?
That's okay.
again?
Mr. Rosman will pass the matter, okay?
Oh, my God. There goes my award.
We're
You're up to billions.
Your Honor, do you care which one we bring in next?
I kind of like
Nope, that's fine.
How about
Whoever you
me?
have.
How about me?
Mr. Rosman, we're gonna pass your matter right now.
How about if I have her as my attorney?
All right, Mr. Rosman, let's go.
We're gonna pass your matter right
No,
now,
it-
sir.
You had your chance.
I can't hear.
Mr. Rosman, we're gonna pass your
Stand
matter.
up, let's go.
What is this?
This is jail.
I didn't hear the judge.
You're in custody. They've been speaking clearly to you.
I didn't
Why
hear
are you
them.
listening to it.
She's looking like that. I didn't even hear it. I got tinnitus. I can't hear well. You
I don't
can't.
know what that is.
You're ringing in the ears.
So my name isn't Dickhead, so
I
let's.
didn't say dickhead.
Okay, all right.
My ear buzzes. I can't hear. This person could
Mr.
be
Rosman.
sent me back to jail. It's funny,
Mr.
huh?
Rosman,
I'm listening.
we're gonna
You
pass,
think I'd be
we're gonna
quiet?
pass. Mr. Rosman, we're gonna pass your matter for a minute, okay?
Okay.
We're gonna have handle
you
some
put
other
me in
matters and
jail.
then we'll handle your case, okay?
But I'll be in jail still. Right?
Well,
Yes.
you're gonna be in jail, you're gonna be in jail for a little bit longer until we get this taken care of. So, yes, but,
Okay. Throw me in
okay,
jail.
so we'll pass your
There
matter.
there goes my jury award up to over $1 million.
Okay, let's go.
You, I don't want. If I come back, will you be my attorney still here?
All right, keep your pants
Let's
on.
go.
Do not put your pants
Nobody
on
does.
again.
Pull them down.
Do not do that again.
Pull them down. They don't fit. Don't they?
Come on.
Good. This one there was-
The door open.
Oh, door's open.
Sorry
you,
about that,
Detective.
Your Honor.
That's okay, it happens.
that
I'm sure you're a great attorney. Happy holidays.
Yes.
Oh, gosh. I think the other ones are less energetic, I'll say.
Madam,
Okay, good.
Yeah.
thank you.
It's a little much early in the morning.
Yeah, I know, right?
Right.
I haven't had my first cup of coffee yet. I'm like, what is happening right now?
What are you adding to his charges?
Well, probably indecent exposure.
Jeez, okay.
So that's why I made the comment about his pants. I
Oh,
didn't want,
boy.
I really thought he was going to expose himself to you guys.
Okay. And to everybody on YouTube. So just so that you're aware of that.
Oh, okay, there's that too. Yep, perfect.
Yes.
Thank you.
Okay. Thank you, Detective. Who is this, sir?
Oh, that was fantastic. Thank you, Hector. Thank you, Brecken. Thank you, Zach. All that's good stuff. I don't know. It just got me when he said "keep your pants on" because it's a general expression to just relax for a second. You don't literally mean keep your pants on, but in this case, he literally meant keep your pants on. Good times. What a way to start the new year. Yes, I'm in Auckland. Auckland is absolutely gorgeous. Watch the fireworks. I would recommend that to anybody. If you happen to be in the neighborhood on New Year's Eve, go out on a boat and watch the fireworks over Auckland Harbor. It's good times. It really is. It's absolutely beautiful. They did let me in, although I got a talking to. I got a talking to on the way in to New Zealand. And here was the issue I had. I blew right in. I had no problems. You guys want to hear environmental control stories? Because that's what this is. Biohazards. I was a biohazard, apparently. And I will tell you precisely why I was a biohazard. I was a biohazard because I touched a wallaby. So we had to have a discussion with the New Zealand authorities about my contact with a wallaby whilst in Australia. I get it. They're protecting their environment. But and she was a nice young girl too. I had a nice young New Zealand official girl look me straight in the eye and say, "Were those the shoes you were wearing when you touched the wallaby?" And I said, "Yes, ma'am. These, in fact, are those shoes." But I never thought I would hear that question in my entire life. And she said, "Well, okay, you can go." Thank you. You're welcome. You're welcome for my New Zealand entrance story. There you have it. That's all you need to know. This town is absolutely gorgeous, as was Sydney. I recommend it to anybody. Good times. Thanks for coming out. I'll see y'all soon.